Hi investigators, Mike Evans from the Australian Security Academy, fresh from another 3 hours in makeup and hairstyling to bring you today episode 99 of Spy Curious, the program for private investigators, government investigators and corporate investigators. And this program today is part... G'day Jamie, good to see you mate. How's things down in beautiful Victoria? This is part of our Victorian Police Licensing Compliance Program where we must deliver 24 hours of online live training. Hi, Renee. Great to see you, Renee. Really good to see you. You're down in Victoria too. I hope it's beautiful down there. I'm sure it is. You're coming out of lockdown. Well done, Jamie and Renee. Okay, so today our program is going to be, well, I probably really shouldn't be telling you this. But today is about listening devices, recording conversations, taking photographs, and that sort of thing. What are the rules? Now, to get the rules, you can't rely on just the state of Victoria, which this program is for. We have to have each state because you might cross a border and unwittingly do the wrong thing in another state. So we've got to explain it state by state. So we'll go Queensland first, then Victoria, then New South Wales. And the reason for that, you'll find out, is because even television programs, news services get into trouble for what they record and what they put up online. G'day, Shell. Great to see you. Hope you're having a wonderful day, Shelley. It's always nice to see you. Great for checking in. Thanks for that. Brightens my day when everybody says g'day, like Jamie, Renee and Michelle. And anyway, people, so today we're looking at recording conversations. Now, this doesn't just affect government investigators, private investigators, and corporate investigators. It affects the general public as well. So the one that made headlines a few years back in Victoria was this young lady when she was a schoolgirl and she was Ricky Nixon's girlfriend. And what she did, she took an offensive photo of Ricky. Here he is. This is as offensive as it gets. There's Ricky in his jocks being offensive, right? Almost overexposed in that photograph. And she took that photo. Now, it's all right to take the photo, but what she did, she put it up online. And that's where she went wrong. And she got herself into real trouble for publishing the photo that she took without Ricky's consent. That photograph destroyed his AFL consulting career as a player manager. And so basically this young lady got into a lot of trouble over it. Ricky's featured in the news down there this week again after writing his book from his side. He fought back, but he got himself in trouble. We mentioned this organisation back in series 2 of this series, and it's Yarra Trams. And Ricky's gone psycho on a tram and had a big rant and gone off his nut. And someone's complained, and as you can see down the bottom, Yarra Trams has launched an investigation into this incident following the complaint. So as you've seen on Spy Curious, which we have on Fridays, Yarra Trams recently advertised for an investigation person. And what you're going to be doing as an investigator working for Yarra Trams, not just tram crashes into buses and taxis and vehicles and tradie vehicles and stuff like that and other trams, it's going to be people's behaviour on the tram. So Ricky's got a double whammy today. He's been in published photos on the internet. He's gone crazy on a tram. So it's been a lot of fun. Thanks, Ricky, for keeping us all employed. But the other one that's gone out there as far as published recordings and use of listening devices and that sort of thing has been these two. They were once a happy couple. They are mum and dad to a young child, and they have split up, and there has been some recordings made. Now, the gentleman on the right, he wants his recordings back. And the lady on the left, she's gone and published some of them or something, got herself into trouble with a $500 fine in court. So that's been going on there. Now, what's wrong with these recordings? Well, his lawyer says the recordings were made illegally without consent, and he's looking into taking action against the lady. It's a normal boyfriend-girlfriend stuff, mood swings, fights, what can you say? This is what lawyers do when they're trying to make trouble for the other side. They hint around things and they say the tapes were spliced and have been edited and all this sort of thing. And then there are other people who are saying that on the tapes it says he's going to have to hire someone to kill someone, and that's a quotation that's in one of those recordings that Sean Buckley has allegedly said in the recording. So it's sort of a big bun fight, as you can watch playing out in the court in Victoria. So here's the lady who took the recordings. She's overexposed in this photo. Apologise for that. But anyway, this is what's happening in Victoria in the court at the moment. And the police have placed charges this time on this guy for using optical surveillance equipment and installing a listening device, which is what we're talking about today. So we are right on the money and very contemporary with what we're talking about. And you're never going to be right on the money and contemporary as far as what you're talking about goes unless you listen to Pat Flynn. Now, those examples you just saw of Ricky and Sean and Zoe, whoever they are, Zoe was a lawyer, I think. I don't know. In hair and makeup for 3 hours. It's grueling stuff before I get on here. Don't get much chance to research everything accurately. But investigators do stupid things with photos and video recordings. There's a Facebook surveillance Facebook hate group that places video of subjects in the surveillance hate group. Now, if someone in that hate group didn't like the person that did that and they went and showed that to WorkSafe, whether it was Victoria or South Australia or Western Australia, wherever it was, then that person's going to lose their job over it. They're also going to be taken to court over it because they had no consent from the subject to put that recording up. And if they were actually recorded if they actually employed legitimately by a government department such as WorkSafe, TAC, Treasury, Tax, Centrelink, Services Australia or something like that, their service level agreement, or any insurance company, their service level agreement would say you're not to redistribute any videos that you took during the course of your surveillance. And it would be a breach and you would lose your job. That's what it says in the client service level agreement. So therefore, it's very important that you as an investigator don't go publishing any of the recordings you make, whether they are recordings of conversations or recordings of people taking video. Now, in this presentation, it's a classroom presentation, and you're going to see a gentleman talking about, wearing a listening device when he's actually with ladies alone. Now, that's standard practice. He's an older person, and if there are any complaints about what he does or what he says or what he did, he's got the recording of it. And he gives examples of where that has actually happened. It's not to record the person to say, you said this, or you said that. It was done to protect the investigator against complaints made about them. Now, the reason for that is that an investigator can go and interview someone about their general insurance home and contents claim or their stolen motor vehicle, and their claim could be denied. Then the first thing that person will do is complain about the investigator and say how they behaved this way and that way, and they said this and that. And that recording will be the protection for the investigator against that sort of thing. Can they do it? Well, you can't do it in one state, but you can do it in 2 others. Let's have a look at the presentation.
Recording. If I'm a private investigator, being a male, if I was to interview a female alone in her house, I would definitely record that. Just from the point of covering my backside and ensuring that, if any allegations are made, I've got some sort of backup here. So I generally record anything that I do with people here in Queensland. Covers your backside, protects your rights as a party to the private conversation should the other party or parties falsely deny or lie about the conversation should its occurrence or content ever become an issue. So if there's any allegations of any misconduct or impropriety on your behalf, nothing wrong with playing that recording. We had two situations, the company I used to work for as a private investigation manager, we had two situations where people made complaints against our investigators, and the investigator said, "Oh, is that right?" They said, "Have a look at your email in 5 minutes." And they emailed us the voice files, and one of the ones was a particular female said, "The male investigator came into my house and I took immediate offence to him." This was the complaint. When he spoke to me, he was scratching his groin. After a short time, he then wanted to use my toilet, which I found offensive. And anyway, that was the allegation. When we heard the voice recording, it was all no problems whatsoever, even to the point where the investigator said, "So at the end of the process now in our interview today, is there anything you wish to add or alter or clarify?" "No." And he actually said, "Are you satisfied with how the insurance company's been, treating you and dealt with you over this matter?" "Yes." "Are you satisfied with how our interview's gone today?" "Yes." So we just emailed that to the insurance client and they said, "Not a problem." So he covered his backside by just making that recording. Okay, now there's another exemption here. Section 45(2)(d) is made to a person who has or is believed on reasonable grounds by the person making the communication or publication to have such an interest in the private conversation as to make the communication or publication reasonable under the circumstances in which it was made. To break that down into sort of common sense English, if I had a conversation with Mike and Mike said, "You know that Bill Smith, I really hate him. I am going to go about setting him up, I'm going to get him into trouble, and I'm going to get him the sack because I don't like him." Now I can go to Bill Smith and play the recording that I've had with Mike and say, "Look, I think you might want to have a listen to this." So that's basically what that says. So if the conversation concerns someone else who it is relevant, reasonably in the circumstances, nothing wrong with playing that to them and saying, "Heads up, just mind yourself." So, yeah. What does it mean? It is legal to play the recording or show notes or a transcript to your manager, your client, your legal advisor, to show what was actually said and by whom, if a dispute arises or if an allegation is made against you. The key words are reasonable grounds and reasonable under the circumstances. Now, let's go to Victoria. Victoria, in some ways, is similar. It extends on that, and I'll explain that at the end of the process, but I'll talk about just audio recordings just at this point. The legislation in Victoria that regulates surveillance devices is the Surveillance Devices Act 1999. Again, we'll go back to that definition. A listening device, like we did with the Invasion of Privacy Act in Queensland, means any device, again, can be the glass against the wall, capable of being used to overhear, record, monitor or listen to a private conversation or words spoken to or by any person in a private conversation, but it doesn't include a hearing aid. Now, the hearing aid situation means it's something to enhance audio for someone who's got impaired hearing, where the voices that they're actually using to enhance via the hearing aid can be heard by the normal, natural ear of a person who's got good hearing, and all they're doing is amplifying that because they had a hearing impairment. So it doesn't include a hearing aid. Again, private conversation, exactly the same as Queensland. Means conversation carried on in circumstances that may reasonably be taken to indicate that the parties to it desire it to be heard only by themselves, so that reasonable expectation of privacy, as I said before. Does not include a conversation made in any circumstances in which the parties to it ought reasonably expect that it may be overheard by someone else. So the cafe, standing next to someone at the football. If you're standing next to them and you can hear them talking by just standing there in a public place that's publicly accessible, not a problem, not a problem, even though you're not a part of that conversation. So the offence section, same thing as Queensland. A person must not knowingly install, use or maintain a listening device to overhear, record, monitor or listen to a private conversation to which the person is not a party without the express or implied consent of each party to the conversation. Now, there's a word there in the second line, start of the second line, maintain a listening device. The Surveillance Devices Act in 1999. That was created by the area where I used to work in Melbourne, where we only had listening device legislation back then, and we had cameras that we wanted to install. We had tracking devices that we used. There was no provision to have warrants for those. It was always a grey area. It was never tested in court. We always shuddered thinking, I hope we're not going to be the test case where case law is, you know, determined as the result of something we've done on a really important case that we were working on. So the maintain listening device, there was always a problem where we had warrant periods for 3 weeks. That's it, full stop. And you had to get the listening device out within that 3-week period. So if you had troubles getting the person away from their house or getting access to the premises where the device was installed, you had a definite milestone where you had to get that device out by the date. Now, back prior to this, the regulation of listening devices was that extreme that we used to have to fill out a listening device register. The register had every detail about when it was installed, who installed it, who was present, all the people named on the warrant, when it was installed, when it was removed, and we had to sign off this listening device register every occasion we used a listening device. That register used to get tabled to state parliament. It was that serious back then. So that was the maintain thing. So they brought in a situation where we could get extensions on our warrant to get it out if we couldn't get access to the premises. So that's where that came from. Okay, what does it mean? Same thing. You can use a listening device to record a private conversation that he or she is a party to. Doesn't include placing a listening device, as I said before. Same thing, be careful with what you do afterwards. Can't communicate or publish a record or report. Person must not knowingly communicate or publish a record or report of a private conversation that has been made as a direct or indirect result of using a listening device. I'll just extend on this. Listening devices in Victoria are managed under the Surveillance Devices Act, as are optical surveillance devices. So cameras, video cameras, they're actually regulated in exactly the same way as listening devices. So where you have a private conversation, in respect to video cameras, it's a private activity. So it's exactly the same. If you swap and change private activity to private conversation, exactly the same. Now, you remember that girl that had the affair with Ricky Nixon from the St Kilda Football Club? Where she committed the offence was, she was quite entitled to record the video inside the motel room. The moment she posted it online on her Facebook and social media, that's where she committed the offence by communicate or publish. Same thing with the video. I'll come back to video at the end as well. Again, we've got exemptions. Section 11.2, subsection A, doesn't apply to a communication or publication made with the express or implied consent of each party to the private conversation. Again, if you're going to have that consent, record the consent. Record the person giving you consent. Again, in Victoria, very similar to Queensland, doesn't apply to a communication or publication that is no more than reasonably necessary in the public interest. Journalists, again, for the protection of the lawful interests of the person making it, exactly the same as Queensland, so there's no issue with that. Doesn't apply, this is section 11.2c, to a communication or publication in the course of legal proceedings or disciplinary proceedings. So it extends, the Victorian legislation extends to the point where it covers HR people. So in Victoria, HR people can share those recordings in amongst, you know, other HR people in the area where they work or within the industry directly involved with the investigation. Okay, New South Wales. Now this is a different ball game. Totally different ball game. The Surveillance Devices Act 2007 in New South Wales replaced the old listening device legislation. Now the listening device legislation in Canberra is exactly the same as what the New South Wales Listening Device Act was. Now the Surveillance Devices Act in New South Wales is exactly the same as Victoria in that it regulates listening devices, optical surveillance devices such as cameras, video cameras, binoculars, telescopes, all of those sorts of things. And it's regulated in the same way as Victoria. Now your definition of listening device in New South Wales, again very similar. Any device capable of being used to overhear, record, monitor, listen to a conversation or words spoken to or by any person in conversation. So it doesn't have private conversation there. Victoria has private conversation, it just has conversation here. So there's nothing in regards to that private conversation issue which Queensland and Victoria had. Again, same thing, doesn't include the hearing aid, and that's specified in that section. So what is a private conversation? Now they've broken it down here. It's a little bit more complicated in New South Wales. Any words spoken by one person to another person or to other persons in circumstances that may reasonably be taken to indicate that any of those persons desire the words to be listened to only by themselves or by themselves and by some other person who has the consent express or implied of all of those persons to do so. It doesn't include a conversation made in circumstances in which the parties to it ought reasonably expect that it might be overheard. So it's exactly the same as Queensland and Victoria in the fact that you've got the reasonable expectation of privacy issue and you've got the public place or the open area where you can hear with your natural ear. So the offence section, section 7.1. A person must not knowingly install, use or cause to be used or maintain a listening device to overhear, record, monitor or listen to a private conversation to which the person is not a party. And then it says, you're not allowed to use a listening device to record a private conversation to which the person is a party. So down there, you just can't do it. So it doesn't matter whether you're a party to the conversation like in Queensland and South Australia, you just can't do it. Whether you're in the conversation or you're not, can't record it. Okay, now this will take a little bit of explanation. Section 7.3. Subsection 1b does not apply to the use of a listening device by a party to a private conversation if all of the principal parties to the conversation consent expressly or impliedly to the listening device being so used. So you have to get permission from all of the people to record that conversation. Now the question that I'll raise just now, which will cause confusion, is what is implied consent? Now the implied consent is how most people in New South Wales record conversations, and they do it as a matter of course. Now, where you have to get express consent, so you ask them, can I record this? Yes, you can, no problem. Again, record the consent or whatever like that. So how do you deal with implied consent? The way that it's been explained to me by every detective that I ever knew in New South Wales is, they say, I would inform the person at the commencement of the conversation, "G'day Mr. Smith, how are you? My name's so-and-so. I need to talk to you about whatever, or ask you questions about so-and-so. I intend to record this conversation." And then if they keep talking and the person makes no objection, that is implied consent. So the fact that they've been told, I am going to record this conversation, and the person says nothing in return, that is implied consent. So don't worry too much, because right at the very end of this presentation I'm going to cover something that will just tidy that up. I know everyone's head's buzzing going, oh, but what if? You know, but what if? Yep, if you tell someone you're going to record and they don't object, or don't formally object, Not a problem. That's implied consent. So, and it's got to be everyone. Generally though, most times, you'll only be talking one-on-one with people most of the time when you're having a conversation with someone, generally. But you've got to get the express consent of everyone if there's more than one person. So, this is a bit of a confusing section, section 7.3. Subsection 1b doesn't apply to the use of listening device by party to a private conversation if a principal party to the conversation consents to the listening device being so used and the recording of the conversation, 1, is reasonably necessary for the protection of the lawful interests of that principal party. So it doesn't say anything about implied or express there. That's not in that section. So if you're going to record the conversation to cover your backside, you would need to raise the issue of getting that consent to record that conversation. However, I will clarify that at the very end. And then the second part, it's like 7.3b2, is not made for the purpose of communicating or publishing the conversation or report of the conversation to persons who are not party. So if you're having this conversation and it's purely in regards to protecting your lawful interests, that's okay. But you're not allowed to also make it just for the purposes of sending someone a copy of that recording, and this is what we spoke about.
So if you're a domestic violence...
Yeah, a little bit of a hard one. So but again, as an investigator, it really is not something that you're going to be dealing with. It's I've just got this piece of the legislation in there for completeness. Same thing in New South Wales. You can't communicate or publish a record or a report of the private conversation. So it's a person must not. So section 11.1, a person must not publish or communicate to any person a private conversation or a report of a private conversation that has come to the person's knowledge as a direct or indirect result of the use of a listening device in contravention of a provision of this part. So, same thing, you're not allowed to publish or communicate the conversation. Section 1 does not apply if the communication or publication is made to another party in the conversation, so that's not a problem. I can give that to you guys if we're in New South Wales. And it's got, this one here has, with the consent express or implied of all principal parties. So again, same deal. I intend to publish or send a copy of this recording to so-and-so. If no one objects to it, that's implied consent.
How about the utilities in New South Wales? They're the greatest criminals of it. One will tell you, do you mind if we record you? We're going to record this for training purposes. Whereas other banking institutions and insurance...
They should. Look, as I said, don't overcomplicate things with telephone calls. Because as I said, this is talking about meeting someone face to face and having a conversation with them. Telephone calls are managed under the Commonwealth Telecommunications Act. It's a completely different ballgame. So as I said, try not to busy your mind with something that's not relevant to this. This is just talking to someone, whether you can record the conversation and what can I do with it afterwards. That's really what we're looking at. So, okay, now this is where I'm going to clarify something. A lot of people are totally unaware of this case law. Certain legislation regulating the use of listening devices contains sections deeming it illegal. Oh, hang on, let me go back. Sorry, I missed this one. Not only in New South Wales are you allowed to record conversations, if you are in possession of a recording, you're committing offence by just having that recording and possessing it. So if you've got a copy of a recording on your phone or on a laptop or something like that, just the sheer fact of having that and possessing that recording, that's an offence in New South Wales as well. So, yeah. So this one here, illegally obtained evidence. So, I suppose playing devil's advocate, I would just straight out tell someone I intend recording this conversation. They didn't make an objection, I would record it. And if something came of it later, you've always got this as a backup. Bunning v. Cross. It's a 1978 High Court of Australia decision. certain legislation regulating the use of listening devices contains sections deeming illegally obtained evidence inadmissible in civil and criminal proceedings. The Invasion of Privacy Act in Queensland basically has that in there to say that you're not allowed to use the evidence that you obtain via an illegal recording of a conversation. New South Wales Surveillance Devices Act has a section in there to say you can't use illegally obtained recordings by the use of a listening device. However, Bunning v Cross is a game changer. Bunning v Cross says that improperly or illegally obtained evidence does not inherently render it inadmissible. However, the ruling confers upon a judge a discretion to reject it. The ruling of the High Court of Australia in this case has been formulated as an exclusionary rule. Namely, it places the onus on the accused to prove the misconduct and to justify to have the recording or the evidence excluded. So it throws it back on the person who's done the wrong thing for them to justify why it should be excluded. So it's not straight up, illegally obtained evidence is not straight up struck out and not used. You can get the judge to make a ruling and actually have illegally obtained evidence introduced into a court case. So the next part is here, this sort of explains it a little bit more. In civil and criminal proceedings, evidence that was obtained improperly or illegally is not to be admitted unless the desirability of admitting the evidence outweighs the undesirability of admitting the evidence. So, given the manner in which it was obtained. So if it's been illegally recorded, quite often, depending on the seriousness of what that evidence reveals, it will get in, it will be admissible, and it will be ruled admissible. So when the judges make decisions in regards to that discretionary rule as to whether they're going to allow it or they're not, the three main things they look at here that they take into account is the probative value of the evidence. So if you have an illegal recording, but that illegal recording really goes to prove something really serious, the probative value of that recording is much stronger than the fact of the illegal recording. The second thing they'll look at is in the importance of the evidence in the proceeding. So if there's no other evidence and that really has really strong probative value, you can use that and it will be admitted, and they will take that into account. And again, the last part, the gravity or impropriety of the contravention. I recently did a program in the ACT where they have very similar legislation down there where you've got to get consent and everything like that. They don't have the Surveillance Devices Act in Canberra, they have the Listening Devices Act. But the question came up in respect to how do we go when we have a claimant who lives next door to a person who's been cruel to an animal, and they climb the fence and they go and take video of the cruelty or the neglect or the non-feeding, non-watering of the animal, and then they go back over the fence and they give that video to us. They all said, can we use it? And I said, Bunning v Cross, I said, a trespass by climbing across the fence and taking some video of animal cruelty, I said, that'll get up, no problem. I said, do me a favour, I said, ring your legal advisor at the RSPCA, and I said, ask them that question and say, does Bunning v Cross apply? And they came back from lunch, and one of them, who was the team leader, said, yep, our legal advisor said they would use it definitely. It would get up, not a problem. So Bunning v Cross is your sort of, that's your little bit of a backstop in case, things are a little bit iffy. So that implied consent thing, if that becomes a point of challenge or a point of issue, you've always got Bunning v Cross in the background to just back that up a little bit. Legislation regulating the use of listening devices differs from state to state. You must know and understand the legislation applicable to your jurisdiction. Very important. You need to know what you can and can't do. Some journalists back a few years ago, Queensland journalists went to northern New South Wales. I think they were down Mullumbimby or somewhere down there, or somewhere Yukon or somewhere like that. And they actually made some video and audio recordings of a person in the course of their journalistic sort of stuff. They actually got charged with the illegal use of listening devices and stuff because they didn't realise that they weren't allowed to make those recordings in New South Wales like they were in Queensland. So let's come back to cameras. I'll just talk about cameras now. It's not part of this presentation, but I'll talk about cameras. In Victoria, in New South Wales, and a number of other states where they have surveillance devices legislation, Tasmania and places like that, the optical surveillance devices are managed in exactly the same way as listening devices. So you've got your private activity as opposed to private conversation, reasonable expectation of privacy, and how it goes there is you're only allowed to obtain video, photographs, or view things from or within the view of a public area, a publicly accessible area. You're not allowed to go out of the way to do something abnormal to get that video, such as climbing onto the back of your ute and holding the camera up over the fence. You can't do that. In Victoria, that legislation came in first, and in the private sector, as private investigators, everyone has adopted the same thing. All the clients right across Australia have gone, let's adopt that safe process in the fact that within the view of or from a public place. So they do that. You're not allowed to climb a tree. You're not allowed to do something that, like back in the day, we had investigators in Queensland that ex-army guys, they were happy to climb a tree and take video of, what they were doing and sit out the bush and do things like that. So you're not allowed to trespass on private property to take video. So you can't go to a neighbour, like a farm. You can't go to a paddock in the farm. If it's private property, you can't do it. If it's public land, such as a state forest or the verge on the side of the road before you get to the property line, that's not a problem. But as soon as you get onto private property, you can't do it.
You set a ladder up on the verge.
Yeah, you just can't do it. So that's the way it's sort of adopted. Now in Queensland, there's nothing that regulates cameras at all here. The only reference to the regulation of cameras here in Queensland is, I can't remember the section numbers, but there are 2 sections in the Criminal Code Act here in Queensland that regulate the fact that you're not allowed to photograph the private parts of people. So it's to stop blokes upskirting women when they're going up on the escalator and things like that. That's the only legislation in Queensland that regulates that. So there's nothing here other than the listening device legislation. So cameras are just open slather up here.
How good's that?
Yeah, it's just, look, the legislation is 1971 for God's sakes. All the other states, 1999 is probably the next oldest, and it just needs to be reviewed. What else?
They won't change it.
Yeah, I think we've sort of cut. Oh, now the next thing I'll do, I'll sit down to do this. I know there was a question raised by someone in respect to going onto properties and things like that. So, under the Invasion of Privacy Act, and I'll just bring this up now just to show you on the screen here.
They sit out all day. Yeah, you can't.
Okay. So, in the Invasion of Privacy Act, after the listening device legislation, we have invasion of privacy with respect to dwelling houses. Now, this is purely Queensland, nowhere else, just Queensland. So, Section 48A, and I'll work through the Act here just to show you. There's two little parts to this that you've got to be really, careful of in regards to going onto properties. So this first one here, any person who enters a dwelling house without the consent of a person in lawful occupation, or where there is not a person in lawful occupation without the consent of the owner, you're committing an offence. So basically, going onto properties where people aren't home, you can't do it. Now, in regards to entry to land, there is what they call a tacit invitation to enter the property, where if there is a front gate and there's a driveway or a footpath leading from the front of the property towards the front door, the tacit invitation is, okay, my gate's open, here's my front path walking up to the front door. Anyone who wants to come and knock on the door is quite free to knock on the door. You can't go, oh hang on, doesn't look like there's anyone home, and walk out and around the back of the house, because that tacit invitation only allows you to go to the front door, the nearest door to the house by the most direct route from the footpath. So you can go there, knock on the door and leave. You can't go squirreling around having a look in the properties and stuff like that. So that's the first part. If an offender gains entry to the dwelling house, so entry to the dwelling house, so you can't go to the house. Sorry, down a bit further here it talks about yards as well, but the house itself, you can't go inside someone's house without having permission to do it. So this is one that's really, you've got to be really careful of as a private investigator, particularly the surveillance guys. If an offender gains entry to the dwelling house by force, that's fair enough. Threats or intimidation of any kind, or by deceit. So, you know when you go to the front door and you're doing a pretext inquiry to find out the person's name and you're telling them some tale of how you're trying to find out what their name is by telling them some tale, and if you've got someone who's very friendly and says, oh look, no problem, come in here and I'll write it down for you. The moment you step across that threshold of the door, you commit an offence because you've entered a dwelling house by deceit. So telling that story, you've committed an offence. Way back in the late 80s, some police up here actually got in trouble because they installed a listening device using a uniform from one of the power companies. Because they entered the dwelling house by using deceit, bang, they've committed that offence and the whole matter was thrown out. So, yeah, so by any fraudulent trick or device, so deceit, fraudulent trick. So that pretext inquiry, be careful that you don't actually walk inside the house. And it goes on a little bit more here to talk about yards and things like that as well. But
what about waterways, Pat, back on the surveillance, if you're in a public water, there's many waterways around Queensland.
That's cool.
So is that okay?
That's cool.
There?
Yep, that's cool.
Joe,
If it's publicly, in where Mike lives,
yeah.
Probably not, because it's regulated in there, it's secure, you're not allowed to just be a member of the public and drive your boat in there because you'll get stopped. So that's different, but any of these other canals and stuff like that, not a problem. So I think we've covered most of that. Any questions with this? It's
Can I ask a question, I guess, regarding like age and consent and things like that? So say you're into someone's house and you talked about you're going to record their conversation,
Yep.
and there was a parent and then there's a child like running around like a 10-year-old or something.
good question.
And you said, will you at so-and-so's house on such a date? And they're like, no. And they're like, yeah, you're there on the way back from grandma's house. So what does that mean?
Good question. Now, in Victoria, all of the clients down there, the Work Cover Authority, the Victorian Work Cover Authority, all your insurance clients, all of those people there, if they're dealing with a matter that's done by way of surveillance, or they're conducting surveillance by way of how they're managing the claim, strict under the code of conduct, like the code of practice, the Victorian Work Cover Code of Practice, if you're taking video of a claimant, if there's children there, you are not to film the children. So I suppose to draw a parallel to that with the conversation and the audio recording, I would probably err on the side of that safety too. Same thing, the codes of practice in the private sector are fairly strict. You know, you're not allowed to video, even if the claimant is a school teacher working at a school, you can't video inside schools. They've even gone to the point in Victoria of saying that if you go to a restaurant or a shop, this is how far it's gone. If you go to a restaurant or a shop, the shop's open, it's open to members of the public, but what is the shop there to do? It's there to sell things, goods and services. So if you're going in there with the purpose of getting video for a work cover claim, you're not going there to buy something or purchase a service, so therefore you're entering that shop not within the reasons why that shop's in existence. So the code of practice in Victoria for the Victorian Workcover Authority have even extended to the point where you can go to the shopping centre and take video in the actual body corporate area, but you cannot go through the door into the shops and take video of people. So that's how far it's gone down there. And the rest of Australia is pretty much following that sort of lead.
Pat, I'll just get you to go outside now with 7 people, if you wouldn't mind.
And Pat's presentation just came to a very abrupt end. People, you have been watching Listening Devices, everybody's favourite subject. So, in having watched that, considered what happens in New South Wales, considering what happens in Queensland, considering what happens in Victoria, you now have insights into what may develop with these matters in relation to the secret recordings from Ultratune and what happened in the Ricky Nixon undies case with the then schoolgirl girlfriend who's all grown up now. So it's not just applicable to police, private investigators, surveillance operatives, IBAC, that sort of, it's ICAC, it's applicable to private investigators, corporate investigators and government investigators as well. And you saw how it works in Victoria in that presentation by Pat Flynn. I'm Mike Evans, and after another 3 hours in hair and makeup this afternoon, I'll be back later on today with another episode for the Victorian Police Licensing Regulation Division compliance of live training delivery at the Australian Security Academy. Thanks for watching. See you there.